SwayamPrabha. Digital India. Educated India.
Okay, well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. This is my 12th lecture to which I am going to discuss. The topic of today's discussion is protection against self-incrimination and use of narco analysis. So, in this lecture, I will try to highlight the role of scientific techniques, scientific methods which are used by investigating agency just to obtain confessional statement from the accused. So, what would be the value of that statement which is obtained by investigating agency after supplying chemical to the accused, after using narco analysis, brain mapping, DNA test, fingerprinting, beep test. So, you might be aware about these methods, these techniques. Nowadays, investigating agencies are using this kind of scientific techniques to investigate the matter for interrogation purposes. So, we will try to understand how narco analysis, how brain mapping, how beep test may be helpful in interrogation and what would be the value of that statement which is obtained by investigating agency by using these techniques, these methods. So, I have chosen this topic so that I can explain you the relevancy of scientific evidence, the relevancy of statement given by accused under these circumstances, under narco analysis or brain mapping. And you see, right against self incrimination, that is a kind of protection given in Article 20 Clause 3, and let us understand Article 20 Clause 3 and then we will have to see Article 20 Clause 3 in the light of narco analysis, in the light of brain mapping, how things can be considered under Article 20 Clause 3. So, you see, Article 20 Clause 3 says that no person shall be compelled to be a witness against himself. So, Article 20 Clause 3 talks about non-admissibility of compulsive witness, where any statement is given by a person which might implicate him in any offence cannot be considered as a piece of evidence by the court of law. So, firstly you will have to understand that this kind of protection is given to the victim. On the other hand, investigating agencies are not bound to take such a statement which might implicate somebody in any offence. So, protection is given to the victim, to the aggrieved, and agencies are also prohibited not to take evidence, not to take statement from the accused in such a manner. Article 20 Clause 3, it gives liberty to a person not to speak, not to give such a statement which might implicate him in any offence. Whenever a person is compelled by investigating agency, by police to give a statement which may be inculpatory, which may implicate him in any offence, at that very moment any person who is being compelled by police officer to give a statement against him can say that I am protected by Article 20 Clause 3. Article 20 Clause 3 of the Indian Constitution, Supreme Law of the land, gives liberty to me not to speak before you, not to give a statement before you which might implicate me in any offence. So, this kind of protection is a fundamental right. As you know, the moment any person is compelled to give a statement against his desire, against his will, he or she can take shelter of High Court or Supreme Court directly under Article 226 and 32 of the Indian Constitution. As you all are aware that Article 32 of the Indian Constitution says that Supreme Court shall have power to issue any order or direction or the writs in the name of habeas corpus, mandamus, quo warranto, certiorari, prohibition for what? For the enforcement of fundamental right. So, Article 32 clause 2 says this thing. Article 32 clause 1 says that any person whose fundamental right is violated has right to come before the Supreme Court. So, right to file, right to appear before the Supreme Court in case of violation of fundamental right is itself a fundamental right. So, Article 32 clause 1 gives liberty to each and every citizen of this country to appear before the Supreme Court if his or her fundamental right is violated by the government. So, right to move before the Supreme Court for the enforcement of fundamental right, it is itself a fundamental right. Ubi justi be remedium, where there is right, there must be remedy. So, Article 20 clause 3 and Article 32, that aggrieved has right to come before the High Court under Article 226, he can or she can file a petition before High Court by stating entire facts that he or she was compelled by investigating officer on a particular date and time. He was compelled by police officer to give a statement, such a statement which would have implicated him in any offence. So, he denied to give a statement, he was tortured, he was assaulted by the police. So, all these things can be pleaded before the High Court and Supreme Court under Article 226. As per the convenience of aggrieved, as per the convenience of the victim, High Court and Supreme Courts are available to accept the application petition of the aggrieved or victim where he or she has been compelled to give a statement against. So, no one can be witness against himself. If somebody is compelled by police officer to become witness against himself, at that very moment his right would be fundamental right is violated and he or she can come before the High Court or Supreme Court for the enforcement of fundamental right. Apart from this Article 20 clause 3, in order, or you can say in order to supplement this, what would be the value of that statement which investigating officer has obtained from a person? That statement will have no value in eye of law. Why? I just want to explain this concept in the light of statutory provision, so that you can get entire information pertaining to Article 20 clause 3 and that statutory provision wherein it is specifically provided that confession made to police officer or confession made in police custody would be irrelevant. That cannot be proved against the statement maker. So, now come to my next slide. In this slide, Article 20 clause 3, no one shall be compelled to be a witness against himself. Right to privacy, Article 12 of UDHR. Right to privacy is human right provided in UDHR 1948. You must understand it, right to privacy. Right against inhuman treatment, cruel punishment. Article it is that right is protected, guaranteed under Article 5 UDHR. This is my fundamental right not to be treated inhumanly. So, inhuman protection against inhuman treatment, that is human right. So, authorities are bound to treat any arrested person humanly. So, it would be otherwise it would be violation of their human rights provided in Article 5 of UDHR. Right against, which talks about right against inhuman treatment, cruel punishment. Now, come to this next slide. confession made to police officer. What would be the value of that confession which is made by an accused to the police officer? You will have to consider the relevancy of that statement which is made by an accused to the police officer in the light of section 24 Indian Evidence Act 1872. Section 25 confession made to police officer is irrelevant, that cannot be proved against him, that cannot be considered as a piece of evidence. Section 26 confession in police custody is irrelevant. Section 27 any material or substance recovered by police irrelevant. So, protection against self incrimination article 20 clause 3, you will have to read this provision section 24, 25, 26, 27 with respect to article 20 clause 3. So, I will try to explain you how article 20 clause 3 and the statutory provision of the Indian Evidence Act 1872 are directly connected. As you might be aware about section 24 of the Indian Evidence Act, section 24 of the Indian Evidence Act says that no inducement or threat shall be given by police to an accused for what? For obtaining a statement from that accused. So, where any kind of inducement, any kind of threat is given by police to an accused to extract, to obtain confessional statement, it would be irrelevant, that statement will have no value. So, the point which you need to remember is section 24 of the Indian Evidence Act indirectly protects an accused from custodial violence, from custodial torture. Why? Because section 24 says that where threat is given, where accused is induced, any kind of inducement is given to an accused by police, that if accused will admit his guilt, his punishment would be reduced, he would be released by the police officer if he confesses guilt. Whether that accused confess his guilt or not, it would be immaterial. If he has confessed his guilt due to that inducement, it would be irrelevant. If he has not confessed that guilt, it would be irrelevant. So, the purpose behind giving this liberty to the accused is to avoid custodial torture, to avoid custodial violence, to avoid police atrocity, which police frequently, oftenly uses against the accused. So, no inducement or threat shall be given to accused for obtaining statement. Section 25 Indian Evidence Act also makes it clear that confession made to the police officer would be irrelevant. Article 20 clause 3 says that a person who is an accused shall not be compelled to give a witness. So, any person who is an accused of an offence shall not be compelled. This kind of compulsion would be violation of fundamental right. Authorities are prohibited not to use any third degree method, not to use any other method means to obtain statement from the accused. They are prohibited by article 20 clause 3. But even though if investigating authorities, if they obtain any confessional statement, for example, section 25 says that where confession is made by an accused to the police officer, that statement cannot be proved against the accused in the court of law. Meaning thereby, where an accused has admitted his guilt to the police officer, that he killed, suppose if accused, he says that he killed Mr. X. If he has confessed, if he has admitted this kind of statement to the police that he killed Mr. X due to just to take revenge of his father's death, he killed Mr. X. So, this statement will come within ambit of section 25 of the Indian Evidence Act, due to which this statement cannot be considered as a piece of evidence by the court. Court cannot consider this statement as a piece of evidence. 26 of the Indian Evidence Act, it is also supplementary, it is also helpful to make more effective, to make Article 20 Clause 3 more effective. How? Section 26 says that confession made by an accused in police custody, police officer and police custody both are different things. So, 26 protects such a statement, confessional statement which is given by an accused in police custody. So, any statement which is given by an accused in police custody which is of confessional nature, that statement cannot be proved against that accused as a piece of evidence. You can understand this with the help of example, where an accused X has admitted his guilt in police custody that he killed Mr. Y with this weapon. That statement cannot be considered as a piece of evidence because that statement was made by an accused in police custody. Reason behind not accepting this statement as a piece of evidence is the fear of police, the fear of punishment, the apprehension in the mind of statement maker. Though police officer has not given any kind of threat or inducement to the accused, but law presumes that mere presence of police before the accused would make apprehension in the mind of accused, and whatever statement is given by that accused would have been given by him due to apprehension of threat, due to apprehension of inducement. So, that is why law presumes that this kind of statement should be excluded from the judicial proceeding. Court should not rely on that statement which is given by an accused to the police officer or in police custody. So, because of threat, because of fear in the mind of statement maker, statement is not, law presumes that statement is not voluntarily, statement made by accused, that statement is not made by that accused voluntarily. So, that statement should be excluded from judicial proceeding, that statement cannot be considered as a piece of evidence. So, because of these prohibitions, because of the protection of section 24 of Indian Evidence Act, because of section 25 and 26 of the Indian Evidence Act, confessional statement cannot be considered as piece of evidence. So, you will have to refer all these things in the light of Article 20 Clause 3. But section 27 is more important. Section 27 is an exception, and this exception is more important than rule provided in the previous sections. What is section 27 of the Indian Evidence Act? Section 27 says that where statement is made by an accused to the police or in police custody, that statement cannot be considered as a piece of evidence, but if any material or substance which is recovered on the basis of statement of the accused, that material, that substance, that arms and weapons which accused has used in that crime, if that arms or weapons are recovered by the police officer on the basis of statement of the accused, that weapon, that arms or weapon can be used as a piece of evidence against that accused. Why? Section 27 permits this kind of material evidence which is recovered by police officer on the basis of statement of the accused. So, one thing which you need to remember that section 27 is an exception, and whatever material, whatever arms, articles and arms, weapons used by an accused in that crime, if that is recovered by police, that can be proved as an important piece of evidence against the accused. Section 27, where this all these things will have to consider in the light of judicial pronouncement. Now, let us see what is the role of section 27 in admitting the facts, materials recovered by police officers on the basis of confessional statement. So, we will try to understand the interrelation between Article 20 Clause 3 and Section 27 of the Indian Evidence Act. With the help of this slide, I will try to explain you that Article 20 Clause 3 and DNA test, fingerprinting, and then we will try to understand the consent, informed consent and compelled consent. Then we will try to understand human right issues like right to health, consent is not voluntary. So, all these things we will try to understand in this lecture. Article 20 Clause 3 and DNA test. Suppose where DNA test is conducted for what? Just to establish the paternity of a child, who is father of that child. So, with the help of this DNA technique, paternity of a child can be ascertained. So, where investigating agencies are using this method, DNA technique to establish the paternity of a child before the court, no person can deny that he or she will not give, that person will not give his blood sample for DNA test, because giving blood sample would be violation of Article 20 Clause 3. He cannot take defense of Article 20 Clause 3 merely on the ground of DNA test, that giving blood sample or specimen signature or handwriting thumb impression would be, might expose him, or that is compulsive witness. Nobody can take such kind of defense, because statement is prohibited by Article 20 Clause 3. No person shall be compelled to be a witness to give such a statement which may be against him. So, that statement is prohibited by Article 20 Clause 3. Arms and weapons, material which is recovered by police officer on the basis of confessional statement. So, material substance is not part of statement. So, material or substance might be used against the accused. So, you need to remember this thing. Now, I am coming to that point where Supreme Court has specifically, categorically held that only statement is prohibited, protected under Article 20 Clause 3. Material substance which is recovered by police officer on the basis of statement of accused, that is not prohibited by Article 20 Clause 3. So, DNA finger impression, DNA test, that is not prohibited, that may be allowed. Consent, as you see, it is said that in narco analysis test, the chemical which is used by intravenous method, the chemical medicine which is used to get information from the accused, to obtain statement from the accused under narco analysis test or brain mapping test, it might affect the health of that accused. So, right to health, that is a fundamental right, and accused, now he is a suspect, he is an accused, So, law must presume him innocent unless his guilt is proved before the court of law. So, because of that concept, that accused should not be given intravenous chemical medicine, because it will definitely it will affect the health of that accused. So, humanitarian organizations they have raised objection regarding use of narco analysis test or brain mapping test. Even accused who is put in narco analysis test or brain mapping, consent is not free consent, that is compelled consent. So, that accused is compelled by investigating agency to give his statement in that method, in that way. So, it should be prohibited, it should be. So, this kind of objection has been raised by international organizations, by humanitarian organizations. Supreme Court has also intervened in this matter. I will try to explain that case, Selvi case, in coming session. Now come to this another important case law, where Supreme Court has highlighted that narco analysis test and brain mapping test, how far these two tests are helpful in deciding a criminal case. So, with the help of this case, I would like to, I have chosen this Selvi case. You just look at this analysis of Selvi case. This is a leading case on narco analysis test. Srimati Selvi and others versus State of Karnataka, AIR 2010 Supreme Court. As you all might be aware about, right to remain silent is a fundamental right under Article 21. Right to remain silent. No person can be compelled to speak against his desire. Right to remain silent. What happened in Selvi case? You see, in Selvi case, there was allegation against Mrs. Selvi and two other persons, that the daughter of Selvi, she wanted to marry with a person, with a man which belonged to different caste. Selvi didn't permit her daughter to contract marriage with that man which belonged to different caste. So, Selvi daughter, she refused. She decided to marry with that man. One day, that man was brutally killed, found dead. So, FIR was lodged against Srimati Selvi and two other guilty associates, that they killed that deceased, they are involved in that incident, and FIR was lodged. Police officer, they sought permission from the district court to obtain their statement after using brain mapping, after using that technique, narco analysis. District court allowed that test, gave permission to the investigating agency. So, Srimati Selvi, she knocked the door of Karnataka High Court that narco analysis test should not be conducted. Ultimately, you see, they filed a special leave petition before the Supreme Court. The Supreme Court didn't allow the investigating agency to conduct this narco analysis test. Now, question before Supreme Court was whether narco analysis test or brain mapping test should be allowed, and Supreme Court got the opportunity to discuss the various aspects of narco analysis test and brain mapping test. Law was not clear on this point. So, Supreme Court for the first time in 2010 issued various guidelines regarding use of narco analysis, use of brain mapping test during the investigation, and what would be the value of that statement which is obtained by investigating agency on the basis of narco analysis test, on the basis of brain mapping test. So, Supreme Court has categorically laid down principles in this case that investigating agencies are bound to follow, and subordinate court, trial courts are also bound to follow that guidelines which Supreme Court has issued in this case. Now, let us see that guideline, and I would like to discuss that guideline one by one. Now, you can just look at your screen, look at this, what Supreme Court said. It raises the important legal issue with respect to involuntary administration of impugn techniques. The techniques, brain mapping or narco analysis, that is very painful also. So, Supreme Court, a 3-judge bench held that involuntary administration of impugn techniques violates the right against self-incrimination. It protects accused, not if, you just correct it. It protects accused, suspect as well as witness. Second, third is no test should be administered unless, no test here means neither narco analysis nor brain mapping nor beep test, any kind of test. No test could be administered unless by consent of accused, unless with the consent of the accused obtained before judicial magistrate in presence of liar. So, Supreme Court has given direction that accused must be allowed to have a lawyer, to have advocate. Accused would be at liberty to call his lawyer, to call his advocate, and in the presence of advocate of the accused, that test may be conducted. And before conducting narco analysis test or brain mapping test, it is legal duty of judicial magistrate to ask the accused whether accused is willing to conduct that test, narco analysis brain mapping test. Only then investigating agency can conduct this test. The fourth one is apex court held that it violates the basic human rights of an individual, it amounts cruelty and is an intrusion on mental privacy. So, this narco analysis test or brain mapping, medical expert, when Supreme Court was deciding this case, Supreme Court also invited a medical panel through which Supreme Court wanted to get information that what would be the implication of this narco analysis or brain mapping test, how does it work, and whether the narco analysis test or brain mapping test may affect the health of that accused. The medicine or chemical which is used by doctors by intravenous method, whether that medicine is harmful. So, Supreme Court took the advantage, and Supreme Court also obtained the medical advice on this point. So, medical expert, they provided a report to the Supreme Court. No doubt medical team experts, they informed the Supreme Court that undoubtedly these techniques, chemicals used, medicine used in these methods, that is harmful for a healthy man. So, that is harmful for accused also. So, considering all these relevant factors, Supreme Court held that neither narco analysis test nor brain mapping test would be conducted by investigating agency unless consent is given by the accused in the presence of his counsel, in the presence of his lawyer, and magistrate will have to certify that it is the only way through which investigating agency can obtain the statement from the accused. Otherwise, these tests shall not be conducted by investigating agency. So, one thing is very clear which you need to remember, that this scientific method narco analysis or brain mapping can only be conducted, can only be used with the consent of the accused in presence of his advocate and with the permission of the magistrate, area magistrate, jurisdictional magistrate. Judicial magistrate will have to certify that this is the only way through which investigating agency can obtain the statement and can start the investigation. It would be helpful. Otherwise, the second important point which you need to remember in this case is, in Selvi case, Supreme Court has made it clear that the statement obtained from the accused on the ground of narco analysis or brain mapping test cannot be used as a piece of evidence in the court of law. That statement cannot be used against the accused. Why? So you see, you need to remember this thing, that what is the evidentiary value of that statement given by that accused. In such situation, that statement will have no legal value in eye of law after 2010. So, this is the second observation which Supreme Court has made, in this case. The third important thing is that, which you need to remember, Supreme Court has not prohibited these methods. These methods can be used by the investigating agency after following the due procedure, after following the procedure prescribed by the Supreme Court. What is that procedure? Consent will have to be obtained, means accused must be willing for narco analysis. That consent must be obtained by a police officer in the presence of advocate, lawyer of the accused, as well as that consent must be duly certified by the judicial magistrate. Only then narco analysis and brain mapping test can be conducted. Third important thing is that this narco analysis test and brain mapping test, whatever statement is obtained, that statement will have no value. That statement cannot be proved against the accused. So, what is the use of these techniques? Supreme Court said that these methods can be used by investigating agency for interrogation purposes. So, investigating agency, they can use this method in the rarest of rare case, in exceptional cases, just to collect evidence on the basis of the statement of the accused. If weapons are recovered, arms and weapons are recovered, that material, that substance can be proved before the court of law. That may be. So, this technique, this method can be used by investigating agency for interrogation purposes, not for trial purposes. So, this is all about your Selvi case analysis, and I try to explain you. Now, another important aspect of Selvi case is, petitioner argued that Article 21 also includes right against cruel and inhuman or degrading treatment. As I said, Article 21 of the Indian Constitution, that is directly connected with a right against inhuman treatment. In Sunil Batra vs. Delhi Administration, AIR 1979 Supreme Court has already held that in Sunil Batra case, Sunil Batra was a Delhi administration, that where prisoners of Tihar jail had been put on bar feeders, handcuffing bar feeders. Supreme Court held that India has adopted Universal Declaration of Human Rights. India is a party of International Covenant on Civil and Political Right. So, India has given consent to follow the rules prescribed in International Covenant on Civil and Political Right 1966. We have expressed our international commitment in that document, in that international instrument ICCPR 1966. So, India too is bound to respect the rights mentioned in that civil and political rights in that international instrument. So, Supreme Court referred that international instrument in Sunil Batra case and said that a right against inhuman treatment is human right, and so now time has come to recognize that right in our legal system. So, right against self incrimination, right to fair trial, right against degrading cruel punishment, all these human rights have got due recognition in our legal system, in Indian legal system. So, we all should thank to the judiciary, to the Supreme Court, particularly Supreme Court, which has played important role in recognizing these rights, human rights, in the part 3rd of the Indian Constitution, particularly Article 21 of the Indian Constitution. So, this is the analysis of Selvi case, and I must understand that you all have understood Selvi case. Selvi case is a very important case on this point. Now, come to this Nithari serial murder case. As you all might be aware about the fact of this case, Nithari serial murder case, the name of case is Surinder Kohli versus State of UP, and this fact I have mentioned the facts of this case in a very precise form. A recovery of 15 skeleton of children in Nithari village near Noida. Many of you might be aware about this incident, Nithari serial killing case. Narco analysis test was conducted, DNA report was also there, medical report, and with the help of statement of accused Surinder Kohli, he also, Surinder Kohli was prosecuted for committing murder of children, about 15 children in this case, because 15 skeletons were recovered by investigating agency, and on the basis of when Surinder Kohli, when Surinder Kohli was put under that brain mapping test, narco analysis test, the state, on the basis of his statement, few skeletons were recovered by investigating agency. At the same time, the statement of the accused under section 164 CRPC, you might be knowing about section 164 CRPC, that whatever statement is given by a person under section 164 CRPC, that is known as judicial confession or statement made before judicial magistrate. So, where accused has confessed his guilt, admitted his offence before judicial magistrate, that statement is considered as substantive piece of evidence, important piece of evidence, and it may be a sole basis of conviction. On the basis of that statement, accused may be prosecuted and convicted. This is the ground reality of section 164 CRPC. This is the implication, legal implication of section 164 CRPC, that whosoever has admitted his guilt before judicial magistrate. That statement, that is known as judicial confession, and on the basis of that judicial confession, that accused may be convicted. So, in Surinder Kohli case, Surinder Kohli admitted his guilt before the judicial magistrate. When the photographs of few missing children were shown to him, to Surinder Kohli, he recognized that he killed that child and he was in habit of killing. He was actually a psychic killer. So, he recognized and he confessed his guilt before judicial magistrate. Now, trial court considered this case, Surinder Kohli case, as a rarest of rare case. Considering this case, Nithari serial killing case, as a rarest of rare case, death sentence was awarded to him. Session court, district session court awarded him death sentence, death penalty, considering that case rarest of. You all might be knowing that in Bachchan Singh vs. State of Punjab, AIR 1980 Supreme Court for the first time evolved the doctrine of rarest of rare, and Supreme Court said that where a person is killed in a brutal manner, in a brutal way, so on the basis of manner of commission of murder, if that comes within rarest of rare case, so trial court would be at liberty to award death penalty to the accused. Otherwise, life imprisonment should be a rule and death penalty should be an exceptional. In exceptional circumstances, death penalty may be awarded to the accused. So, Supreme Court in Bachchan Singh vs. State of Punjab case evolved criteria for determining of death penalty, whether death penalty should be given or life imprisonment. Supreme Court said that if case comes within purview of rarest of rare, exceptional case, so trial court would be at liberty to award death penalty, because law was not clear on that point, because you all might be knowing that in section 302 IPC, either death penalty for murder cases, either death penalty, death sentence may be awarded or life imprisonment may be awarded by the trial court. So, law was not clear on this point. Court was at discretion to award death penalty or life imprisonment in a murder case. So, Supreme Court said that life imprisonment should be a rule and death sentence should be awarded in exceptional cases. So, this is an exceptional case. Nithari serial killing case was an exceptional case because 15 skeletons were recovered, and that case was considered as a rarest of rare by the session court, and he was awarded death sentence, death penalty. But his master Moninder Singh Pandher was acquitted by the Allahabad High Court. Doctrine of rarest. See, with the help of this slide, I will try to explain you this case. The doctrine of rarest of rare was applied in this case. Surinder Kohli was convicted for murder, but Moninder Pandher was acquitted by Allahabad High Court, because Allahabad High Court did not find adequate evidence, sufficient evidence against Moninder Pandher. Surinder Kohli was a domestic servant working there. He was domestic servant of Moninder Singh Pandher. So, initially FIR was lodged against Surinder Kohli and Moninder Pandher under section 302, 364, committing murder after rape. So, all the allegations were against Surinder Kohli and Moninder Pandher. But the outcome of this case is, you see, ultimately Surinder Kohli filed petition in Supreme Court. So, in one case Surinder Kohli has also got relief from the Supreme Court in this case. So, this is all about your Nithari serial killing. What the point which I want to justify, that is the use of narco analysis, the use of scientific method, how scientific methods, brain mapping or narco analysis has played important role in criminal justice system. Now, let us see the implication of consequences of scientific techniques, brain mapping or narco analysis. This is, you see, right against cruel or inhuman treatment is a human right. This is provided in UDHR, Universal Declaration of Human Rights, Article 5 makes it clear that punishment should not be cruel. Inhuman treatment, that is also prohibited, and protection against inhuman treatment, that is also a human right given in Article 5 of this international instrument. So, scientific technique like narco analysis, brain mapping, which degrades, which are very harmful, which are very painful, so that should be avoided. So, Supreme Court has said that it is a right to, you see, right to life, procedure established by law, all these things are provided in our legal system. Constitution talks about fair trial, right to life is a fundamental right, and no person shall be deprived of his life or personal liberty except procedure established by law. So, all these protections are given in our legal system, in our constitutional scheme. Article 21 and 22 is there. We have also adopted this method. But apart from this, I would like to refer one case which you all might be knowing. You just look at this. One case was decided by Supreme Court, State of Bombay versus Kathi Kalu, AIR 1961, Supreme Court. 11 judges were there. This case was decided by 11 judges of Supreme Court. Briefly, I have referred this. This is a very leading case. DNA test, blood samples and palm impressions, specimen of handwritings, signatures. You see, this case is important from that perspective, wherein Supreme Court held that when accused is compelled by investigating agency to give his blood sample, to give his palm impression, thumb impression, to give his blood sample, so that further investigation can be carried out, it would not be a violation of Article 20, Clause 3 of the Indian Constitution. So, in this case, you see how State of Bombay versus Kathi Kalu case. This case was decided by 11 judges of the Supreme Court, largest bench in criminal case as of now. So, Supreme Court majority of judges were in favor of giving liberty to the investigating agency, and they majority expressed its view, majority judges, they expressed their view that whether blood sample or fingerprinting or thumb impression that is obtained or accused is compelled to give his blood sample, it would not be violation of Article 20, it would not be compelled witness, because where accused suspect gives his blood sample, thumb impression to match their signature, where signature document is fabricated, manipulated. In case of fabricated document, manipulated document, if signature is required, then that accused cannot take defense of Article 20, Clause 3 that he has been compelled to give a witness against himself, because statement is prohibited. Whatever statement is given by accused, that is prohibited, but document is not prohibited. Supreme Court made it clear that Article 20 clause 3 protects the statement only, where a person is compelled to be witness against himself, that is protected by Article 20 clause 3. But if any material or weapon is recovered, then that is not prohibited. And if DNA test is conducted, you see DNA nowadays, DNA technique is used by investigating agency, and DNA is very effective technique method to expose the identity of the accused. As I told you that where a paternity of a child is in question, matrimonial dispute comes before the court, and a man who is suspect that a child may be a father of that child, so that man cannot deny to give his blood sample. He cannot deny to undergo to that DNA test should not be conducted. So he is bound to give his blood sample, and Supreme Court has held in this case that giving blood sample or conducting DNA test would not be considered as violation of Article 20 clause 3, because that is not protected by Article 20 clause 3. So you all might be aware that in Rohit Sekhar versus Narayan Dutt Tiwari case, when Rohit Sekhar had filed a paternity suit against his father, so Delhi High Court directed him to give his blood sample, but he refused to give blood sample. But ultimately, when Delhi High Court again directed that you are bound to give your blood sample, DNA test was conducted, and ultimately paternity of that Rohit Sekhar was established before the court. So how a person can deny to give his blood sample where he is a suspect in a case? So with the help of this DNA test, the matter dispute can be resolved. So in that case, no one can take the defense of Article 20 clause 3. So that is different from Article 20 clause 3. You all need to understand that statement is prohibited, protected by Article 20 clause 3. Material which is recovered on the basis of a statement, that is not protected. So all these things will have to consider in the light of Article 20 clause 3. So I think I have covered each and every aspect of Article 20 clause 3, narco analysis, brain mapping, and I do hope that you all have understood the things which I have just discussed just now, and you all would get success if you consider this Article 20 clause 3. I have covered each and every case which Supreme Court had decided in the light of Article 20 clause 3, and with this I would like to conclude this lecture. Thank you.
When Copernicus said the earth revolves round the sun, it was considered blasphemy. When Galileo said the earth was round, we thought he was mad. When Darwin said that monkeys are the ancestors of man, we thought he had lost it. When the ecologists said this was the end of the world and the human race, we didn't believe them.